it's not getting legal advice from you, you're okay. And the tax issue, by the way, is that the joint tenancy property, like any other property, if a person dies, leaving property to someone else, the property you leave to someone else, or the portion of the property, gets stepped up in basis to its fair market value as of the date of death of the person. So if you have two people, two brothers, say, who own a property, a little office building, and one dies, and they bought it at $100,000, now it's worth $1 million, and let's make it a wife and husband instead. It's an office building, though, because I don't want to get into the $500,000 or $250,000 exclusion of gain on a principal residence. I don't want to make this overly complicated, like I'm not making it complicated right now. So, when there's a difference in tax treatment for purposes of capital gain, which is income tax, on the survivor. So if you have a husband and wife who bought an office building for $100,000 and it's now worth $1 million, and the husband dies, and it's joint tenancy property, then the moment that the husband dies, instead of his half having a basis of half of $100,000, which is what the couple paid for the building, his basis gets stepped up to its fair market value as of the date of his death, or as of a date 6 months after his death. So that means it's half of $1 million. So his half, in the hands of the surviving widow now, has a basis of $500,000. The half that the surviving widow already had from when they acquired the property is half of the $100,000 purchase price. So it ends up that in the hands of the widow, that total property has a basis for capital gain purposes of $550,000. So she sells the property and only pays capital gain on $450,000, the $1 million sales price minus the adjusted stepped-up basis as to half. So the surviving widow would end up paying capital gain tax on $450,000, or only $450,000, depending on how you want to say it. That's certainly better than tax-wise than if they had sold it while the husband was living. Then they would have had $900,000 of capital gain. But because the husband's half got stepped up in basis at his death, the surviving widow only has $450,000 in gain. Capital gain in 2013 is taxed federally at 20% plus the California rate. So that means the tax on that sale would be federal would be $90,000, 20% of $450,000 of the recognized gain. But if they had the property as community property, and this applies only to the states that are community property states, which is about 9 states, basically the western United States. Community property law is a concept from Spain and Mexico. That's where we acquired community property. The eastern and southern and northern United States do not have community property. They have other mechanisms for what happens if one spouse dies, what are the rights of the surviving widow or widower in various kinds of property. The western states basically have community property, and that says that the federal tax law says that if it's community property in a community property state, then upon the death of one of the spouses, the entire property gets stepped up in basis to its fair market value as of the date of the death of the first spouse. So all the same thing. They bought the $100,000 property. It's now worth $1 million. The husband dies. And so because they held title as community property, the entire property gets stepped up in basis to $1 million at the date of the husband's death. The surviving widow sells the property and has zero capital gain. Not $90,000, not $180,000 if they had sold it while the husband was alive. So there are tax implications of how the choices that parties make. But again, that's not what you do. I'm doing this to sensitize you to the issues, and you need to, your clients need to get appropriate advice. As long as you don't go down the path of giving advice on these things, you're not obligated. No law or regulation or case says that you are expected to give tax advice. This is not what you do. There are other people that are licensed to do that. And in fact, the case law in California supports exactly this, that if you don't go down this path, the fact that the client is unaware of tax implications is generally not your issue. That's not what you do. So big, important choices for your clients, not for you folks. Want to mention real quickly contingency removal and the importance of actually removing contingencies. Happens all the time that people buyers do not actually in writing remove contingencies. The fact that the number of days goes by that is specified in the purchase agreement, pre-printed 17 days or whatever number is changed, can be any number of days, but whatever that is, longer or shorter. Obviously, buyers are sometimes reluctant to remove contingencies because in case things don't work out, they want an escape route. Well, sometimes sellers are not amused by that fact to find out when escrow is supposed to close in 3 days that the buyer just canceled because there's still an open contingency. You can be creative in terms, or clients can, in terms of conditions of removal of a contingency. I just had one where the issue was that the specialty plumber couldn't determine exactly what was going to be required to solve a problem involving certification of a drainage system. So the buyer said, well, therefore, I can't remove my contingency with that in place. So which is understandable. Buyer needs to have some assurance that this problem is going to be taken care of. And so what worked out in that transaction was remove the contingency subject to the seller delivering a certification that the drainage system now complied with whatever the local requirement was. And if you and that way the contingency is gone, the seller will end up paying whatever the cost is, and you could cap that like you can any other repair item. The parties could agree to a cap on a seller's obligation. But what I'm really saying is, if you are on the selling the seller's side, the list side, it's best to get contingencies removed as early as you can, and not have a very unhappy client when the buyer says, oh yeah, well, I never really removed that contingency after all. Have a nice life. Liquidated damages, real quick item. We're all familiar with this, that on 1 to 4 family residential property that is going to be owner occupied, the maximum that can be liquidated damages is 3% of the sales price. Maximum, I should say, that is presumed valid. So if you read through the rather dense liquidated damages clause that's in the purchase agreement, that's what it says. If you have a purchase price, say, of $100,000, 3% is $3,000, and you have a deposit of $5,000. It doesn't invalidate the liquidated damages clause. It means that the maximum amount that's subject to the liquidated damages would be $3,000, 3% of the $100,000. But if you have a contract where you have an increased deposit, which is common, the buyer to increase a deposit after removal of contingencies or after some particular event, the increased deposit is not subject to the liquidated damages clause unless you have a separate receipt for increased deposit and liquidated damages. That's a form. The CAR form is an RID. receipt for increased deposit, and liquidated damages. Doesn't matter what you put into the purchase agreement, how creative the parties get to make it clear that they want the increased deposit to be covered by liquidated damages. California law says that there has to be a separately signed or initialed liquidated damages clause at the time the increased deposit is made, or else it's not going to be subject to the liquidated damages. So it's an item that you just need to think in terms of for a checklist of what needs to be done at the time that an increased deposit is made. So as always, reality is really better and more interesting than the theory of all of this. That every day, if you watch the news, people in their real estate transactions can manage to get themselves into big trouble. It's all good as long as you're not the person who helped them get into the trouble. And they can hire appropriate spirit guides to get them through their claims, their lawsuits. And a couple of questions. Anybody have a, yes, ma'am?
I have a question. In reference to if you're representing your listing agent, okay, let's do it first with the buyer. If the agent tells you that there's no appraisal contingency, but there is a loan, which is like a 17-day, right? So let me see clarification for that. If you're representing the buyer, regardless of what the appraisal is, but they still, like doing the loan, the lender cannot do the loan because of the appraisal. If you stipulate it and you're the listing agent, right, there is a removal of contingency on the loan, but then saying it that buyer to come up with a different appraisal. Would that be right to say, if you're the listing agent? In other words, there is contingency on the loan.
Right.
But you're saying that there is no contingency on the appraisal. And you clarify it to the buyer, there is a loan contingency removing in 17 days, however days, but buyer to come up with the difference of the appraisal.
So I'm thinking this isn't an entirely theoretical problem. This sounds like an actual issue where there's a deal where they had an agreement and now it didn't quite work out and they have a completely different view of the universe. The buyer says, oh no, I never meant that. You know, I have a different interpretation. The seller says,
because sometimes what
yes.
happens is that the listing agent counters you and saying that there is no appraisal contingency,
right.
but then there's no loan. But you can't get a loan when there's no appraisal. Isn't that true?
You're never, well, probably true. I mean, although I do see more and more loan products as you do, all of a sudden things coming back in that were 2006, 2005 type loan products, right? They're there. They're back on the market. All I can say is that you are better off being as specific as you can. The parties need to be specific because you're right. No lender is, even if the buyer's going to come up with a portion of the of what should have been a loan amount. I don't think currently no lender is going to make loans that I'm aware of without an appraisal.
So does the buyer have the right to cancel?
If the loan does not get approved, and there's a loan contingency but no appraisal contingency,
Unless the buyer comes up with a difference
well,
of the appraisal, there is a loan, right? Is that true?
if you say that in the event, it would have to be very specific. Just too specific. I'll be happy to talk with you about this, but this is too specific for a general answer. You know, it's going to depend on exactly what the language is in the contract. You know, but yeah, I mean, it's theoretically you can do what you're saying. So, anything else? Any questions, comments, criticisms, or jokes that I can respond to?
So, everybody, let's give this guy a
So
big
thank you
hand.
very much for your hospitality.